Hi everyone, this is Senator Sharon Hewitt. I've received a few calls and emails asking for clarification on Senate Bill 359, a bill that lawyers representing a few coastal parishes claim would take $100 million from the parishes that could be used for coastal restoration. Nothing could be farther from the truth. Let me tell you what the bill really does and why there is no $100 million deal. Current state law in place since 1978 recognizes that a statewide approach to coastal management is necessary to ensure consistent enforcement of activities across the coast. These are called uses of state concern. In general, these are activities that make more sense to manage at the state level and have regional, state, or national impacts. Specific examples listed in state law are projects occurring in more than one parish, are all mineral activities, including exploration for and production of oil and gas or other minerals, all pipelines for the gathering, transportation, or transmission of oil and gas and other minerals. These things all make sense to me because they require a more holistic view that extends beyond the artificial boundaries of a parish or municipality, particularly the management of minerals such as oil and gas, whose vast reservoirs, such as the Tuscaloosa Marine Shale or the Haynesville Shale, can extend across multiple parishes and states. Here are the things the law specifically defines as uses of local concern, which should be regulated primarily at the local level if the local government has an approved program. Things like jetties or breakwaters, bulkheads, piers, camps, and cattle walks. These all make sense to me also. Smaller projects within a parish that don't affect other parishes should be managed by local government. State law further provides that the Secretary of the Department of Natural Resources and local governments with an approved program have enforcement authority of their permits. And for 40 years, it was interpreted that the Secretary enforced issues of state concern and the local governments enforced issues of local concern. In 2013, a group of lawyers convinced a few parishes that locals have the authority to enforce state-permitted oil and gas operations and began filing lawsuits against more than 40 oil and gas companies. Now more than 180 lawyers are part of the shakedown, running up a legal tab over 7 years, said to be near $10 million, at no cost to the parishes. The lead attorney was quoted in September of 2019 when he announced a supposed settlement with one of the companies as saying, "Big Oil has to make a quick decision if they're going to try a case or come talk and try to make a reasonable business deal to resolve the cases." This is a great example of why Louisiana is a leader in frivolous lawsuits and is recognized every year as one of the top judicial hellholes in the country. Companies are routinely forced to make a business decision as to whether the cost of protracted litigation exceeds the cost of a settlement and an opportunity to clear their books of a potential liability. It's not about innocence or guilt anymore, it's about the settlement. And in this case, it's not even about who did or who did not violate their permits. Most of the wells in question were drilled before the 1978 legislation required permits. And there's been no evaluation, to my knowledge, as to whose operations really created the damage. So you see, it's not really about the facts, it's about the money. And one of the companies, Freeport-McMoran, has apparently agreed to settle any and all future liabilities in Louisiana so they can once and for all exit our state. They left the oil and gas business long ago and have refocused their business on other mining operations such as copper and gold. For them, I would imagine that it was a business decision to cut their losses and offer $100 million to be free and clear of Louisiana forever. But make no mistake about it, this is not, and I repeat, this is not a done deal. The offer that the plaintiff attorneys regularly refer to as a settlement requires all 12 of the parishes where Freeport previously had operations to sign the agreement, along with the Attorney General and the Governor, according to testimony by the plaintiff attorneys in the Senate Natural Resources Committee hearing last week. Since the announcement of the Freeport-McMoran Settlement in September of 2019, only 6 of the parishes have signed. In fact, the parish presidents from Lafourche and Terrebonne that are supposedly part of this settlement testified in the Senate committee hearing that they have never even seen the agreement and will never sign it, making this whole discussion moot. Plaintiff attorneys testified in committee that until everyone signs the agreement, there is no deal and there is no $100 million check lying on the table. And while I understand why parishes might sign on to a lawsuit that appears to be at no cost to them, the constant risk of litigation in Louisiana has had a chilling effect on businesses and has driven oil and gas companies to invest in other states. Nobody wants to invest in Louisiana with the constant threat of lawsuits lurking around every corner. The lead plaintiff attorney testified in the Senate committee last week by saying, "You want to bring back the industry and bring back economic development in these parishes? I know from experience that they don't come when there's liability." End of quote. That's actually one of the few things he said in that committee hearing that I actually agree with. Big oil left our state a long time ago, but many oil and gas families still live in our communities as the companies have shifted their investments to the federally regulated deepwater Gulf of Mexico. Their charitable dollars still go to fund STEM and other educational programs in our schools, sponsorships for major festivals such as Jazz Fest and the French Quarter Festival, along with restoration projects like marsh grass plantings and beach cleanups, and the hundreds of millions of dollars in federal royalties they pay on production from the deep water comes back to Louisiana to fund the lion's share of CPRA's annual Coastal Master Plan. At my encouragement and the Louisiana Geologic Society, they've collaborated with several of our research institutions to donate and analyze seismic data to predict subsidence and faulting along our coastline, allowing us to make more informed decisions about the sustainability of coastal restoration projects, such as the diversions. They're working with me to clean up our air by reducing our carbon emissions and injecting the carbon underground in a revolutionary carbon sequestration program in partnership with the Department of Natural Resources. We should continue to partner with the oil and gas industry to improve our communities rather than wholesale lawsuits. Current law already provides authority for the state to enforce oil and gas permits. Passage of Senate Bill 359 further clarifies the law that has been on the books since 1978. We all agree that those companies not honoring the provisions of their permits should be held accountable. Passage of Senate Bill 359 does not eliminate the lawsuits, but simply allows them to proceed with the Attorney General and the Governor where they belong. I'm a co-author of Senate Bill 359 because I fundamentally believe that oil and gas permitting and enforcement is a state and not a parish issue. Along with this legislation, I'll continue to author legislation that helps the people of St. Bernard and the other parishes in my district and our state, such as Senate Bill 491 that limits the liability of those companies or individuals who made and donated scarce PPE during the COVID emergency, like masks and hand sanitizer. My SCR 56 requests CPRA and the Department of Wildlife and Fisheries to cooperate to develop projects to enhance the oyster industry. As I mentioned earlier, Senate Bill 353 provides a framework to reduce carbon emissions from our refineries and manufacturing facilities. And I've authored Senate Bill 466 to allow local and state government to utilize teleconferencing during emergencies, and Senate Bill 273 to require registration and reporting of cybersecurity incidents. I'm continuing a 3-year effort to unlock dedicated funds from the state budget with the filing of Senate Bill 308 so we can better prioritize our state's needs, which is especially important during challenging financial times such as these. And I'm going to support the Omnibus Tort Reform Bill, which I'm confident will help lower car insurance premiums for every driver. This has not been an easy session, with the abbreviated time at the Capitol due to the COVID shutdown. But I'm excited to deliver legislation that will help our families and businesses recover and put our state on the path to prosperity. I appreciate your input in this process. And you can go, as always, to SharonHewitt.com to follow me on social media and to get my email updates. May God bless you and your families and keep you safe.